All right, I'm going to begin in a couple of seconds here. All right, 3, 2, 1, here we go. No, wait, I want to drink of water. Okay, now really. 3, 2, 1, here we go. Hi everyone, welcome to Advanced Industry Training here at K-Cura. My name is Eileen Tian. I'm a member of the advice team here at K-Cura. I've worked around 10 years as a web and SQL developer. I spent 2 years as an attorney, and I've got 6 years in litigation support. And we'll be talking more in depth about what litigation support is. Alright, so today's agenda, what we're going to cover is we're going to answer questions surrounding, well, what is litigation? And what is the e-discovery industry? What does the discovery phase of the litigation process look like? And who is involved in litigation, right? Who are the entities and personas that are involved in litigation? And finally, we'll take a look at our competitors in this e-discovery market. All right, what is litigation? Litigation is the method for settling disputes between two parties. So, for example, if I am annoyed at how loud my neighbor is playing his music, I could bring suit against him in a court of law, right? Now, some common types of litigation are personal injury, which you hear a lot about, product defect. So product defect, an example of that would be the GM recall case where the ignition switches on GM cars were defective. Intellectual property cases, this is an examples of this is Samsung and Apple suing each other almost daily, I would say, over patent infringement. All right, and finally we have construction employment. These are just some of the main types of litigation. The one that we'll be using as a backstory for our training today is going to be a little bit different. It's actually a suit brought by the United States against two companies. But we'll get into more detail of that later. All right, so let's go through the steps in litigation. First, a dispute, right? A dispute is what kicks off litigation. It's a disagreement between two or more parties. When one of these parties files a complaint in a court of law, this is what officially kicks off the litigation process. So once a party files a complaint, the defendant must respond. And then we move into the disclosure process. And what this is that, so for example, let's use the GM ignition switch recall case as a quick example here. Once the alleged victims sue GM, both parties are now required to disclose to each other potential witnesses that they may like to call, right? So, for example, if I am an attorney for GM, I would need to disclose to the plaintiffs. I would need to disclose to them identities of maybe some of the key engineers and product managers who worked on this allegedly defective ignition switch. So this, you might ask yourself, well, what is my motivation as the attorney for GM to disclose and Bob the engineer, for example? If I know that Bob the engineer has worked on the ignition switch and maybe has made some serious mistakes on the switch, what's my motivation for disclosing Bob's identity? I could hide him, right? I could just pretend he doesn't exist. Well, I could do that, but chances are the somewhere along the litigation process, someone is going to learn of Bob's identity and run to the judge and complain that, hey, GM's attorney, willingly chose not to disclose Bob the engineer. And at that point, the judge could sanction GM both in terms of fines, and also the judge may find that any argument that I may have made in, in a motion, he could rule that I automatically lose on those arguments because of the fact that I, hidden Bob the engineer. All right, so that's why disclosing any witnesses on your end is you really should disclose as opposed to not disclose. Now, in the real world, attorneys roll the dice a lot, and in some cases they do choose not to disclose a witness, and sometimes that works out for them. Okay, so that's disclosure. Next up is discovery. Discovery is if discovery in this row of blue blocks we have. If I could go back and make this graphic, I would make discovery maybe 5 times the size of the rest of the blocks, right? So discovery takes way longer than any of the other phases of litigation. And Kcura software is really aimed at the discovery process. All right, so what is discovery? This is where parties have to provide data to each other. So as the counsel for GM, I need to discover, right? I need to discover what data GM has that might be helpful to our case. Or I also need to discover what data we have that may be harmful to our case. And same thing for the plaintiffs, right? The plaintiffs, the folks that are suing GM, they need to discover on their side whether any of the victims of the car crashes had prior medical histories that may be used to explain why the car crashed. Maybe that's why it crashed, because they had a heart attack and it's not because of the ignition switch. So both parties have a duty to discover important data on each of their individual sides. And also I also need to discover data about the plaintiffs, and plaintiffs also need to discover data from GM's side. So that's discovery. And of course, the term electronic discovery became relevant because back in the old days, before we had computers, discovery was conducted on everything that was paper based, right? So parties would be exchanging paper, literally paper, with each other. And of course, with the advent of computers, we moved to providing data to one another with hard drives or diskettes or whatnot. So discovery became electronic discovery, and that's how the term e-discovery came to be. All right, and resolution is either the dispute at hand is either resolved by a judge or it settles out of court. So that's kind of the pieces involved in the litigation. Now let's take a look at the players in the litigation. Who is involved in litigation? So first off, we have plaintiff and defendant, right? These are the two parties suing each other. We have counsel, both in-house counsel and outside counsel. The difference here is that, for example, at a corporation like GM's going to have its own attorneys. They would be in-house counsel, but most of the time when suits arise for GM, the 15 or so in-house attorneys that GM has, I'm sure they have a lot more than that, but I'm just using 15 as a random number. The 15 or so in-house counsel are not enough to deal with all the various suits that GM could be hit with or that GM is involved in. And so that's when a corporation or an entity would hire outside counsel. So outside counsel is what you normally would think of as law firms, right? Law firms. So law firms are hired a lot by corporations to assist in their matters, and they are basically, law firms are provide outside counsel support for corporations and other entities. Okay, and next up is litigation support specialist. So, for what a litigation support specialist is, they are the power users of Relativity. Relativity and any other document review platform. Just to remind everyone, Relativity, right, is just one flavor of document review platform out there. There are several different brands and types of document review platforms. So for these document review platforms, the litigation support specialists, they are the ones who know how to turn the knobs, so to speak, of doc review platforms. Thus, for example, when a client gives their counsel, a hard drive of data, someone needs to put this hard drive of data into Relativity, right? It's not the attorney who's going to be doing that. It's going to be the litigation support specialist. The attorneys typically, more often than not, don't know how to load data into Relativity, how to get data out of Relativity. These are technical functions that a litigation support specialist would perform. All right. Next up, contract attorneys. So they are a different brand of attorneys, different from in-house counsel, different from your typical lawyers at a law firm. Contract attorneys, they're hired on a contract by contract basis. So, for example, if GM is involved in a big litigation and there are a million documents that need to be reviewed, typically GM is not going to want to pay outside counsel to review those documents because law firms, the associates at law firms, bill out at a pretty expensive rate, right? So what happens is the a firm like GM would turn to a vendor, which is a vendor basically is an e-discovery company and made up of litigation support specialists and project managers. And a vendor also will usually have on hand like a pool of contract attorneys. So a GM would turn to a vendor and say, hey, can you give me 50 contract attorneys to review these 1 million documents? And the contract attorneys bill out at a much, much lower rate than a typical lawyer at a law firm would. All right. All right. So contract attorneys, they've always been around, but since the recession hit, this pool of attorneys has really grown because jobs at law firms have become a lot more scarce since the recession, and so there are a lot of out of work attorneys out there, but they're able to turn to this type of contract work to keep or to at least attempt to keep a paycheck coming in. All right, then judge and jury. I know that everyone's familiar with what judge and jury are from watching multiple episodes of Law and Order or other TV and or movie shows about legal matters. Okay, let's move on. This is the electronic discovery reference model. What most of you have seen this before. We refer to this as the EDRM. So the EDRM goes left to right, and what this model is it's a framework for how folks should be dealing with data that comes in for a litigation matter from the very beginning of identification of that data to the end, which is presentation. Presentation is basically when the matter goes to trial. So let's take a look at each piece of the EDRM here. Information governance really is just, this runs the course of the EDRM. It's just, this part is just basically saying that all corporations should have rules in place for making sure that the steps in the EDRM are followed and that data is being secured. So first off, we have identification. Identification is when the litigation kicks off, or if you even suspect that you might be sued, you as as GM or any other company, you need to start identifying which of your key employees have data that's going to be relevant to the litigation or to the matter that you're being sued on, right? So in the GM recall case example, during the identification portion here of the EDRM, if I were the GM attorney, I'm responsible for identifying, right? Identifying any key engineers or project managers related to the ignition switch. And from there, we move into preservation. Preservation is where then I need to make sure that the key people I've identified are now running back to their offices to delete data off their laptops and Blackberries or whatnot, right? I need to make sure that their data is being preserved. And typically, I would enlist the IT department's help in doing this. Next up is collection. So once I've identified the folks and the data that I need to collect and I've preserved their data, I need to actually collect the data from their electronic devices. And here, this is where a forensics expert may become involved. And what a forensics expert is this: it's someone who has the knowledge and the proper equipment to collect data from electronic devices in a legally defensible manner. So, for example, if I'm collecting data off of Bob's laptop, right, I can't just hook up an external hard drive to Bob's laptop and then drag and drop the contents of his laptop to the hard drive. That's not the way to collect data, right? Because in just doing that, you're going to be changing the metadata, right? The electronic footprint of each document that you touch. So there's certain programs out there that will allow you to transfer data from someone's electronic device onto, a safe, secure storage location without altering the metadata, without changing the electronic footprint of each document. Once data is collected, we're now ready to process the data. And why do we need to process data? Well, because, let's say I've got a hard drive of Bob's documents. I can't just, plug that hard drive into a relativity server and drag and drop the contents onto the relativity server, right? It's not that simple. The electronic documents from Bob's hard drive need to be processed in order to load it into Relativity. And Relativity, as most of you know, has its own processing tool. There are also outside processing applications that you can use. You can process documents outside of Relativity, but also import them into Relativity. And so what happens during processing? So during processing, this is when metadata for each document is extracted, and also all the text for a document is extracted. And when I say metadata, what am I talking about? All right, well, this is what I'm talking about. Metadata is basically the information about an electronic document. So let's take an email, for example. If I send an email to Bob, right, and I CC Stan, well, the metadata that I can collect from this email would be email from information. Email from would be Eileen. Email to would be Bob. Email CC would be Stan. And author of the email, again, would be my name, and email sent date would be the date that I sent the email. Um, email subject line would be the subject line that I typed out in the email. So all these components are pieces of metadata information about a document. And once metadata is extracted from documents, these can be loaded into Relativity so that when you're looking at a document in Relativity, maybe on the left hand side of the review pane, you would have the text of the document to read it, and then on the right hand side of the pane, you would have all the metadata about that was able to be collected and processed for this document available to be viewed in on the right hand side. Okay, so that's processing, and once data is processed, we can move it into a doc review platform like Relativity so that attorneys can log in and start reviewing the documents, reading the documents, and making decisions about the documents, right? They might read a particular email and decide, hey, this is really, really relevant to our case, and then they would mark that document as responsive, or they could decide, this document is not really relevant, mark it non-responsive. So the review and analysis part are kind of the same thing. Once documents have been reviewed and determined okay to release to the other side, this is where we would move into the production phase. So this is where we would produce documents to the other side or a third party. And all of this, right, identification, preservation, processing, review, production, all of this, it's not A to Z. It's not a straight map A to Z. You could, potentially be in the production phase for a chunk of documents, but then as litigation has been going on, you may have discovered, oh, hey, there was this other potential uh, there's this other key person that also worked on the ignition switch, and so we got to skip back to identification. Now we got to preserve this new person's data, collect the data, process it, and review it. So all these this all of the EDRM provides a great map of how to proceed from A to Z. The components are really quite fluid when you're involved in an actual litigation matter. And finally, presentation is if you actually need to go to trial to present all this data that you've reviewed and produced. Now, the production process, you might ask, well, why would you want to produce documents to the other side, right? Why? Maybe you just want to give them a pile of junk, and then keep all the important documents on your own side and never let them see it. Well, here's the issue with that. Any document that you do not produce, you don't get to present that document at trial. You don't get to use that document as an exhibit at trial. And so that's the motivation behind production, because you can't stand up at the end of trial and surprise your opponent with a hot document and pull it out of your back pocket and say, hey, this is the smoking gun that wins our case. You see that in movies a lot. That does not happen in real life, and if it does, it would be under very extraordinary circumstances that a judge would allow a document to come in like that. All right? Okay. All right, let's move on. Okay, so what does discovery look like? And just to remind everyone, discovery is the largest phase of the entire litigation process. Here, we're going to switch up from the GM recall case that I've been talking about and start talking about the AB InBev case. We'll use this lawsuit as the story to drive the rest of the slides for this section. and we'll talk about how a lawsuit is driven by the EDRM and how relativity fits into the process. So, US DOJ v. AB InBev. The reason you see the beer bottles here is because AB InBev is one of the largest distributors of alcohol in the country. All right, so what was the story behind US DOJ v. AB InBev? AB InBev and Modelo are two of the largest beer distributors in the world. AB InBev was formed by a merger between Anheuser-Busch and the Brazilian brewer InBev. Now AB InBev decides that, hey, they want to purchase Modelo for $20 billion. The DOJ, the DOJ said, hey, time out, hold on. AB InBev and Modelo, we're not gonna let you just merge without looking into this matter. We feel like this is gonna violate some antitrust laws. What does that mean? Well, long story short, the DOJ is afraid that this merger is going to result in folks paying more money for beer, but having fewer selections, right? So imagine if Samsung and Apple, right, were to merge. That would be a little bit scary, right? They could potentially drive up prices for cell phones and any other products, and then there would be less products to choose from. So same idea here. Now, to make sure that the merger doesn't tank because of this DOJ suit, AB InBev and Modelo, they're going to need to review a lot of data and turn that data over to the DOJ to prove that there are no antitrust issues here. Right, so AB InBev's in-house counsel, they hired the law firm McDermott, Will and Emery, or MWE, to help out. And then MWE in turn hires DTI to be their vendor. Now, most of the this example is pretty much on point, but there are a few definitely some historical fiction that I've put in here. And that, for example, I'm actually not quite sure who MWE chose as their vendor, but DTI is an easy example to choose. All right, so how does this suit how does this suit jive with the EDRM? Well, first, the AB InBev attorneys, both their in-house and outside counsel, they needed to determine the scope of the legal hold that they have to cast. So the legal hold is, which key people on AB InBev and Modelo do we need to send out a notice to say, hey, hang on, the US DOJ is investigating this merger. Please save all your data and correspondence related to this merger, and please preserve your data. Next, the vendor DTI will collect data from the people identified in the legal hold, and DTI will process any of the data collected. Once data is processed, it can be loaded into a workspace so that attorneys can start reviewing the documents for relevancy. All right. And at this point, AB InBev and DTI and MWE, they all might decide that analytics may be the way to go in this case. So, for example, if there are just too many documents and if it's a short amount of time that the review needs to be done in, perhaps hiring 100 contract attorneys, maybe that's not very feasible, right? Maybe 100 contract attorneys is too expensive, or maybe the 100 contract attorneys wouldn't be able to finish reviewing this large mountain of data in 10 days time, or some short time frame. This is where analytics comes into play. So let's talk a little bit about analytics, because um, I know that usually folks have a lot of questions about what is relativity analytics. Okay, so relativity analytics, and again, relativity analytics is just one flavor of e-discovery analytics. There are other products on the market. So, um, so analytics turns the linear review model upside down on its head. And what do I mean by the linear review model? Well, it's exactly what it sounds like. It's sitting a human being down in front of relativity and having them review each document one by one. So you start with document 1, you go on to 2, 3, 4, 5, and so on, right? So that's linear review. Analytics is is obviously it's not linear review. The computer is not going through each document in order 1, 2, 3, 4, 5, 6, and so on and so forth. Instead of using 100 attorneys to review 1 million documents, analytics allows you to use just one attorney, one single attorney. Usually this person needs to be a high level attorney who has knowledge of all the facts of the case at hand. You take that one attorney to review a sample, right? Maybe 1,500 documents, right? A sample of the 1 million documents. And once this high level attorney is finished reviewing the sample of documents, the litigation support specialist then would go into the project and click a single button, and then at that point the 1,500 documents that have been coded either responsive or non-responsive by the attorney, these 1,500 documents get sent out into the relativity engine, and the analytics engine is going to try to determine, based on the decisions that the attorney has made about the 1,500 documents, what are other documents within the universe of the 1 million documents, which of the remaining documents in the universe are similar to some of the 1,500 documents, right? So for example, if the attorney has marked document A as a responsive document, if the relativity then maybe will find 10 documents that are conceptually similar to document A, and because document A was marked responsive, the computer will then mark the 10 conceptually similar documents to to document A also as responsive, right? So document A coded by attorney is responsive. 10 of the 10 conceptually similar documents to document A, the computer will then mark these as responsive. So analytics really cuts down a lot on review time, and you basically will do round after round of sample documents, and also you're able to do quality control rounds, so QC rounds, to make sure that the machine is coding documents properly. And then at some point you reach an end game where you see that most, if not all, of the documents of the 1 million documents have been assigned a responsive or non-responsive value, whether it's by the human or by the computer, and and then at that point you can determine, oh well, the project is finished, and you could either immediately produce the documents that have been marked as responsive, or you could, um, or you could also, sit down and, do a final QC check of those documents. All right, that's analytics. There are many, many different types of workflows you can apply to analytics. I just presented the most common one. All right. And last up, of course, once documents have been found to be relevant, this is when they are produced. In this case, this is where AB InBev would produce documents to the DOJ. So if you look at this slide, this one is just a graphical representation of everything that we've been talking about. We start off on the left-hand side with legal hold notices, and then we, move on to collections, and then all the way up to productions. All right, next, let's talk about the roles and personas that are involved in discovery. And most of these we have already talked about. So law firm, we can have in-house or outside counsel. Government, corporation, vendors. So vendors, again, are e-discovery companies. All they do all day long is e-discovery work. So usually all the admin functions you think of in relativity. And finally, we have third-party developers. This one we won't be talking about as much, so let me just cover it here. We have third-party developers that develop applications that can be integrated with relativity. Okay, so let's break down the key entities in the case we've been talking about, US DOJ v. AB InBev. We had the government, which was the Department of Justice. We also had corporations, AB InBev and Modelo. And we had the law firm, MWE. And finally, we had a vendor, DTI. Okay, at this point I need to jump into another deck. It's going to be an older looking deck, so the background and everything is going to be a little bit different, but this other deck will take us through the roles and personas at these various entities. Okay, we're in the other slide deck. Let's take a look at, first up, common law firm structures. So, literally in the real world, people do refer to law firms as small or boutique law firms, medium law firms, and large law firms, or you'll hear the phrase usually big law. As you can see at a law firm, typically it's not just one partner or one paralegal, right? This slide is just breaking a small law firm down into its very, very basic elements. Typically small law firms have anywhere between 2 to 15 attorneys, and their various partners, senior associates, sometimes junior associates, and usually they will have at least one paralegal on staff. However, most small law firms do not have their own litigation support specialist on hand. And so typically small law firms will contract with a vendor like DTI. Medium law firms, these are law firms that have somewhere between 50 to 100 attorneys, and that's not counting, staff like accountants and administrative assistants, project managers, for example. It's just 50 to 100 attorneys. At median law firms, you typically will see at least one litigation support specialist, but this one litigation support specialist will be very, very busy because they're responsible for administering, relativity or another doc review platform for all the 50 to 100 attorneys at this one medium-sized law firm. Now, at a large law firm, you'll see now that we have more staff on hand. I'm not going to go through every single piece, but just to focus in on some of this the lit support roles. So if we start from bottom to top, typically you might have a junior lit support analyst and maybe a more senior specialist. And the terms specialist and analyst, it really gets switched around a lot, so that a specialist at a law firm could be actually less senior than an analyst and vice versa. Typically at large law firms, you will see anywhere between 5 to 15 litigation support specialists. At the last two large law firms that I worked with, we had somewhere around 7 to 8 litigation support specialists at each firm. Right. Now, um, next next up, we'll talk about some of where the law firm roles fit in. But before we do that, I just like to point out that so um, typically at law firms, the litigation support specialist is responsible for the entire life cycle of a case, so that this lit support specialist would need to know everything from how to process data to how to produce data. So they need to know how to process data, how to set up data for review, how to load documents into Relativity and get it out of Relativity, how to run productions, how to run analytics, all of it. Because normally how assignments are given to litigation support specialists at law firms is that you're assigned to a particular case. So a litigation support specialist might be assigned to the GM recall case, or they may be responsible for the AB InBev case, and then they would be responsible for any lit support function that is needed for that case from the beginning all the way to the time that the case goes to trial or settles. All right. This slide is just a one to show where the personas in the law firm would get involved along the EDRM spectrum. So you'll notice that, very high level partners would not be involved at all with processing or review or analysis, right? That would be done all by the litigation support staff. And you'll see that the forensics expert is only involved in, identifying folks and identifying data to be collected and then actually collecting the data. The litigation support specialist would not be involved in that phase. Right? And then the associates, these are either junior level and senior level attorneys who are not partners at a law firm. They would be responsible for reviewing data, analyzing the documents, and then deciding which documents should be produced. All right, paralegals. We haven't talked about paralegals very much, but paralegals assist associates in things like preparing briefs and motions that associates need to file in court or argue in court. And when it comes to putting together material that needs to be used as trial exhibits, paralegals would be responsible for that type of work. And paralegals and litigation support specialists at law firms typically work hand in hand together. Paralegals, of course, they do not do any of the, usually, they do not do any of the admin functions that litigation support specialists would do, such as running productions and loading data. But paralegals usually would, be responsible for running searches for associates. And if it gets into complicated searching, using a lot of operators, that's when they may, turn to the lit support specialist for help. Just as one example. Okay, let's move on to the vendor structure. So you'll notice that this is a lot different from the law firm structure we just looked at, right? Because a vendor is, well, it's one a single company, and it's divided up into forensics and solutions, project management, hosting, and review, and uh, the last part, technology assisted review. That's basically analytics, right? So this slide is pretty straightforward, right? Forensics are the folks that are responsible for collecting data in a legally defensive manner. And solutions architects are the ones where if a client has specific questions on how to accomplish a certain workflow in relativity, they would be calling the solutions architect. The project managers, the PMs, these are the folks who keep a project on track from beginning to end. So they're the ones who are managing whether documents or data being processed by litigation support analysts, whether they are being processed on time, whether data being loaded by litigation support analysts are going into a workspace according to the timeline that was agreed upon, so on and so forth. The hosting the hosting folks at a vendor, if a client is hosting all of their data at the vendor instead of in-house at their own law firm or their own corporation, the hosting folks would be the ones to make sure that all data is secure. These would be akin to our very own infrastructure managers here at Kcura. Now, data is hosted at vendors, or client data is hosted at vendors, but currently Kcura does not host any client data. But with the advent of Relativity 1, that's the direction that we're moving towards. Moving on to the right here, the doc review team, that's pretty self-explanatory. These are the people at the vendor who are responsible for reviewing any client data that's needed. All right, and finally, if there are any analytics functions needed, the TAR or Technology Assisted Review team will step in. So a big difference between between working at a vendor as opposed to working at a law firm on the lit support side of things is that, again, as I mentioned, at a law firm, a lit support person really is the PM, the solutions architect, and the TAR consultant and the litigation support analyst all rolled up into one at a law firm. At a vendor, um, all of these functions are divided up into the various verticals that you see before you. All right. So an easy way to really think about it is if you're working at a vendor, you might only learn about analytics and you might only be responsible for analytics. You might never have a chance to, move to the processing team or the PM team, and for example. Whereas if you are lit support at a law firm, you will get a pretty well-rounded experience there because you're going to be responsible for a case from from the processing step of the EDRM all the way through the production step and including analytics. And so this is a similar slide to what we saw previously, except this is for the vendor. You'll notice it's just broken down a little differently because we have different personas here at the vendor. So that line for litigation support analyst, we should probably break that up, into separate components. Really, for the processing component, you might have, the lit support processing folks, and then for review, lit support review, and then for analysis, lit support, analytics team. Next up is corporate. Corporations are, again, a different animal than law firms and vendors. There's a lot more bureaucratic layers usually with corporations. I'm not going to go through every single piece of this, nor is it necessary to. If you focus your attention towards the bottom of the slide, you'll notice we have some similar roles here to our law firms and vendors. We've got folks involved in lit support. We have project managers and paralegals, and also counsel. All right, and next up is where corporate roles fit in. Again, pretty self-explanatory here. Corporations, I found, even though you see that according to this slide, there's going to be a lit support manager or some kind of analyst that will be responsible for these parts of the EDRM. A lot of corporations actually don't have a litigation support team in place, but we're going forward, we should see that almost all corporations really need to fill this void if they don't already have a litigation support team in place, because data is just getting bigger and bigger. Litigation is always ongoing. We always have someone suing someone else, right? And without someone on your corporate team who understands how to use all of the admin functions and relativity, it's going to be very difficult for that corporation to succeed if they don't work closely with a trusted vendor, for example. And even if they do have a vendor, it's really more beneficial if they have someone on staff who knows how to communicate with the vendor on lit support matters. Okay, I've jumped back into our other slide deck here, and our last topic is, well, who else is in the market? Who are some of Relativity's competitors? Okay, so not going to go through every single one of these, but real quickly, Relativity competitors, or those that compete with us on the document review platform side. We've got Recommind. However, Recommind, I believe, was just acquired by a company called OpenText. LexisNexis makes this document review platform called Concordance. And then one of our closest competitors actually is FTI. They make Ringtail. So those products that compete with relativity processing are two of the major ones, or actually all three are major, but the two of the ones you might hear more often are Nuix and LexisNexis, their law pre-discovery processing application. Now, Relativity Binders was meant to be kind of our trial presentation software, and I'm not sure where development is currently with it, but other trial presentation software out there are one's by LexisNexis and the other one is by InData. And what's a trial presentation application? Well, it's exactly what it sounds like when you go to trial. Instead of producing a paper document that to be used as an example, you could use, for example, Trial Director to flash up on a computer like a big screen, an exhibit. Right. And then lastly, we got some transcript and mapping applications. These compete with our Fact Manager application. So, you know, within any case, you have a timeline of events and important facts, and there are programs out there that will allow you to track these facts and timelines. All right, that's it for the presentation. Typically, here there's an opportunity for a question and answer, but since this is a recorded webinar, there is not. But if you have any questions for me from the webinar, please feel free to contact me. Again, my name's Eileen Tian, and I'm a member of the advice team. All right, everyone, thank you, and I hope this was helpful.